Well, howdy there, folks. James, Political Friar, coming to you again. Got the Baylor law hat on, and so we're going to have a legal topic on this one. Specifically, DC Circuit ruling giving Jack Smith the ability to access Donald Trump's otherwise private direct messages from Twitter. See, August of last year, Jack Smith obtained a search warrant. The target of the search warrant was Twitter, not Donald Trump, but Twitter, and that's because Twitter had within its possession information about Donald Trump's communications, his direct messages that would not have been made public, his draft tweets that would not have been posted, and his draft direct messages. And Jack Smith says, well, in furtherance of our investigation into Donald Trump's activities around January 6th, we want that information, Twitter. And Twitter said no. Twitter said, we're not going to give it to you. You don't have the legal right to it. Donald Trump has the reasonable expectation of privacy in those records, and Twitter was going to stand up for him. Which brings us to a really interesting legal question. Do you, as a user of a social media platform, have a reasonable expectation of privacy such that a warrant doesn't need to be complied with by that entity? And the DC Circuit Court says no. The DC Circuit Court says the rule about search warrants is that you execute them, and then if the evidence turns out that you did have the right to have that evidence protected, then the evidence gets quashed after the fact. You don't get to refuse to turn over the evidence prophylactically. And that is interesting because it means that if any law enforcement agent out there convinces a judge that my emails contain evidence of a crime, my emails, all of them, my medical records, my personal correspondence, all of them could be swept up by a law enforcement agency because there's no way to differentiate. See, the normal thing that happens with search warrants is they have what's called a scope. And that means that you're limited to looking for what you're looking for. But when everything you're looking for is a internet communication, that means you're going to get everything. You can't have a internet company going through and saying, well, this is criminally relevant and this isn't criminally relevant. That would never work. And so outside of appointing some kind of magistrate to go through all those emails, I don't think you have a defense as a internet platform user to having the warrant executed. Now, you can have that evidence excluded after the fact if it's irrelevant or if it's something that you can argue you had a reasonable expectation of privacy for, but you don't get to prevent the government from getting it in the first place. And that is a fascinating Fourth Amendment question. Should that rule be changed? Should that rule be changed such that in your own personal messages, even though they're housed at Twitter, you have a expectation that the warrant should be served on you, not Twitter, such that you have notice that it's happening and potentially the ability to argue that there should be some sort of special magistrate that goes through it so that your reasonable expectation of privacy can be upheld. And I don't know. The DC Circuit Court says no. The DC Circuit Court says no, the normal thing to do is not to quash the warrant, but to exclude the evidence after the fact. That sounds right. That's very much what you would do if there was a search warrant that ended up getting evidence that swept up that was overbroad or some other defect with the evidence that was gathered under a search warrant. But it also really makes me feel uncomfortable because there's no way to have a narrow scope on these sorts of things. Now, Donald Trump has argued another argument. He says that the Presidential Records Act applies here, and I don't see how it does. The Presidential Records Act applies to requests from the public or others to the National Archives, and it has, in particular, it has a process where the president can can object, can say, no, that record isn't something that ought to be made public, and there's an administrative process for adjudicating that if the archivist disagrees. There's no doubt that there are probably presidential records in Twitter's possession, uh, but this request wasn't made to the presidential records. The presidential records custodian, the National Archives. It was made directly to Twitter. So here's the hypothetical. Say there's a physical letter that is a presidential record, and say there's a copy of it. And Donald Trump hands that copy of the physical letter to his friend Rudy. And then he sends the original, to the archives. Can the prosecutor, Jack, subpoena that letter from Rudy and not tell Donald Trump? And the answer is probably yes. If the presidential record is in the custody of somebody other than the archivist, yeah, it's probably fair game. It probably gets treated like any other record. And so I suppose it's up to the president to be aware of that. Although, boy, Donald Trump probably wasn't aware of that. He probably had that expectation that what he was doing on Twitter was somehow privileged, and he's probably wrong about that, but I don't know whether that's going to be the rule the Supreme Court ends up coming up with. This is an area that is ripe for new law. How does the Fourth Amendment interact with the internet tools that we use every day? It's kind of fascinating. If I was going to propose a rule, I would tell the judge and say that the rule is you can get the information from the internet company, and the subject of that information needs to be informed within a reasonable period of time. You can get all the information before the subject knows what's going on, because you can't tell them ahead of time, because that just gives the subject of a criminal investigation the opportunity to destroy evidence. And so you don't have to tell a person that you got a search warrant before you raided their house, and they don't have a right to refuse you entry to their house if you have a warrant. And so the difference is, if you are raiding their house, they know, and they can promptly start the litigation to suppress any evidence that was inappropriate. That would be my preferred rule. That's not the rule as I see it. I think the D.C. Circuit Court probably got it right, but this also means that maybe we will get the Supreme Court taking this up, if not for President Trump's benefit, but for the Fourth Amendment's benefit, because the Fourth Amendment protects you from unreasonable search and seizure. And it specifically lays out your papers. Well, I think email is a pretty good analog to your papers. So I guess we'll have to see what happens. Anyway, it's just a thought. Let me know what you think in the comments down below. Leave me a like, hit that subscribe button, and know I really appreciate you. Thanks.